The Retirement Cafe podcast, the rules for making gifts under a power of attorney with Holly Mieville-Hawkins. Hello and welcome to another episode of the Retirement Cafe podcast with me, your host, Justin King. If you're thinking about your retirement or already retired, you're in the right place. My aim is to help you plan for and live a successful and meaningful retirement. Retirement is far more than just a financial event. It's a significant life event, a major transition, which will bring with it new challenges and opportunities. So each episode contains tips, information, and inspiration to help you feel more informed and confident about your retirement. I hope you enjoy today's episode. Hello and welcome. I'm so glad you've joined me for this week's podcast episode. This week, I'm delighted to welcome back Holly Mieville-Hawkins in our first conversation on the podcast. In episode 130, Holly and I discussed statutory wills and dying intestate. This week, Holly is back to discuss the rules around gifting when you're acting in the role of attorney under a power of attorney. This is a very specific topic, but an important one. Most people want to mitigate any inheritance tax their estate will pay, and this becomes a more acute need as people get closer to the end of their lives. And it's no different when you're acting in a loved one's best interest as their attorney, if they've lost mental capacity. One way to reduce your inheritance tax liability is to gift some of your assets in your lifetime. But the rules around gifting are complex and they're perhaps more ambiguous and subjective when you're acting as an attorney under a power of attorney. So I'm really grateful to Holly for joining me today. Holly is a solicitor who specialises in the court of protection and mental capacity. She sits on the Wills and Equity Committee at the Law Society, which consults the government on issues around mental capacity and lasting powers of attorney. And she is an active commentator in the national media. In this episode, we discuss the important role an attorney plays, how to understand what's in a donor's best interests, how this differs from self-interest, and what this means for gifting. Holly shares a fascinating story about a wealthy lady and her attorney to illustrate the point. The main rules on gifting, on how much you can give away when you're acting under a power of attorney, the role of the court of protection. I hope you learn a lot from this information-packed episode. So without further ado, here's our conversation. Welcome back to the Retirement Cafe podcast, Holly.
Thank you. Thanks, Justin. It's absolutely great to be back. Thank you for having me.
Well, once again, we've desperately arranged this to be in the morning because we know how sharper you are.
Yeah. I know, it's terrible.
I
didn't get a great amount of sleep last night. My toddler was up coughing, so maybe I'm not the sharpest I could be.
Right, so please don't rely on any of Holly's advice today. Seek independent legal advice from a paid professional. So, Holly, thank you so much for the last conversation we had. It was really interesting, all about powers of attorney and deputyships and statutory wills and fantastic amounts of knowledge there. We wanted to move into another area that I know that people can struggle with a little bit, and we have touched a bit about inheritance tax planning, but kind of the classic thing lots of people ask about is, can I give everything away? Yeah. What can I give away? Can I give away money when I'm a deputy?
Wasn't yes, you can give everything away. It was yes. About that.
If I'm a deputy, can I give away? If I've got a power of attorney, can they give it away? There's a lot of gifting. You can understand why people might want to give things away, especially if they know that there's going to be an inheritance tax liability. Yeah. It's a tax bill that is coming, but sometimes is in essence voluntary, because if you haven't got any assets, you don't have to pay any tax. Let's expand on the topic of gifting.
Absolutely. It's one of my favourite topics, actually. So I'm really pleased to be talking to you about it today.
Great. Where do we go? Tell me, why is it one of your favourite topics?
I think it's one of my favourite topics because it's really misunderstood. I think it's one of those situations where attorneys and deputies sort of I think they think that they have carte blanche to sort of give the gifts that have always been made. I think they think that they can just sort of carry on doing whatever the person that lacks capacity had always done, or what they think that they would want to be done. And that's absolutely not the case at all.
Right.
And actually, there are quite strict rules about gifting that are in place. Would it be helpful for me to sort of just give a brief overview about what the basic rules are?
Absolutely, yeah.
Okay, so I won't talk about sort of the mental capacity test as such, but what I will say, because obviously that's been dealt with in other podcasts, but what I will say is when somebody lacks capacity to make a specific decision, i.e. the ability to gift £10,000 to a granddaughter because they're getting married or something like that, any decision about that issue has got to be made in the person's best interests. Now, best interest is defined in Section 4 of the Mental Capacity Act 2005, and I won't bore you with the law too much about it, but basically, you've got to make the decision in that person's best interest, which means you've got to look at their previously expressed wishes and feelings, any sort of written down wishes and feelings that they've got, any conversations you've had. So you can look at the will that they've made, the power of attorney that they've made, look at previous actions they've made. So have they made sort of similar size gifts before? Have they been worried about inheritance tax planning before? Have they taken advice on it? That sort of side of things. Speak to their advisors. You also need to sort of think about your own views as an attorney, or the views of any other attorneys, views of family members, views of anyone that would want to be caring about that person's decision making. So you've got to balance all of this up. It's quite a complex decision-making process, and then come to your best interest decision. And unfortunately, you don't just then have the ability to do whatever you think might be in that person's best interest, even when you've gone through all of that process when it comes to gifting. So the Office of the Public Guardian, who are the sort of government body that monitor attorneys and deputies, have produced a brilliant note about gifting, I have to say, and it can be found on their website. Very, very, in a very standard way when it comes to mental capacity law. There is sort of like no standard approach that applies to gifting, but but there are sort of standard restrictions that are in place. And Section 12(2) of the Mental Capacity Act 2005 says that an attorney can only make gifts where those gifts are on a customary occasion, which means like a Christmas or a birthday or something like that, to people that are related or connected with the donor, or to any charity that that person may have previously given to, where the value of the gift is not unreasonable, having regard to all of the circumstances, and in particular the size of the donor's estate. So basically what this sort of means is like 100, 200 quid can be given at Christmas or a birthday or something like that. And that's okay, provided they can afford it, and the donor didn't sort of say, no, never give any money to Rachel. She's awful. I don't want to give any money to Rachel ever again. If that sort of thing hadn't applied, then it would be fine to give 100 quid to Rachel at Christmas if it's something they've kind of always done. Now, deputies have very similar guidance to that in their deputyship order. And as a general rule, anything over and above that will need authority specifically given to the attorney or the deputy from the Court of Protection. But you can imagine that when the sort of reality of that sort of sunk into the Court of Protection, the attorneys and the deputies of the world, everyone sort of had a slight heart attack and were making so many applications to the Court of Protection that it just became slightly unmanageable for the Court of Protection. So back in 2013, the Court of Protection published a judgment called MJ and JM and the Public Guardian. And this was Senior Judge Denzel Lush, who's a fantastic judge, really sensible, very practical. He was a solicitor at the firm I used to be at, actually. So like he's just sort of been around the block, got it from a practical perspective. And he said, as a really rough guide, sort of the amount that you can go up to in terms of gifting, if the following circumstances are in place. So a person's got at least a nil rate band in their estate, so it's about 325 for most people, £325,000. They've got a life expectancy of less than 5 years. This is the person that lacks capacity. Where the gifts are affordable, taking into account the person's care costs, and they won't adversely, though negatively, affect their quality of life and care, and there was no evidence that the person didn't want to make any such gifts, you can make gifts of up to £3,000 from capital each year, and you can make a gift of about £250 per person from income, up to about 10 people, without additional authority from the Court of Protection. All right. So that's not like in addition to that de minimis gifting from customary occasions rule. This is sort of like your total amount you'd be able to gift in the year is £3,000 from capital, and then about 250 to about 10 people if all of those conditions apply. And that is it. There is no more ability to make gifts whatsoever unless you've got authority from the Court of Protection, and that authority has been specifically given. There is some tiny exemptions where it comes to sort of maintaining spouses and things like that, and you'd need to take specific specific advice about that, because it can get quite complicated about what's a gift and what's maintenance. So I wouldn't advise anyone does anything over and above that sort of £3,000, £250 without seeking specific advice or specific authority from the Court of Protection.
So, Holly, the one thing that I'm not sure you touched on there, which I would think that would be quite relevant, of course, is the affordability of it. So income versus expenditure. We know that some people live on their expenditure is very low, and some people's it's significant. And of course, there's judgment attached to that. Of course, there is. But the reality is, should someone weigh up, the affordability?
Absolutely, yeah, and that's one of the criteria
rather than just
in that case.
The capital, the sums. It's like, well, okay, what are their outgoings? What's their income?
Absolutely, and that's one of the conditions in the MJ and JM case. It says that the gifts have got to be affordable, taking into account the person's care costs, and it won't adversely affect their standard of care and quality of life. That's a crucial consideration.
Yeah. And again, of course, in their best interests. Well, this is an interesting one around inheritance tax, I think. The inheritance tax, of course, doesn't fall. I don't have an inheritance tax bill. My estate does, doesn't it? I don't actually write the check. I will never write a check for inheritance tax.
No, absolutely.
So to save inheritance tax cannot be in my best interest.
Well, this exact question was tested in the Court of Protection. It's funny you should say, in 2018, and there was a case. Where I'll very briefly give you the facts, because I find facts of cases really helpful, actually, when I'm trying to remember them and sort of what the conclusions of them are. There's a sort of elderly, well, not too old, sort of elderly lady in her early 70s, unfortunately, she had early onset Alzheimer's. So she'd been quite unwell for quite a long period of time. And by her early 70s, she was unable to recognise most people, could recognise really close family members, but couldn't make any real decisions about her finances. She had a lot of money. She had about £18.5 million of capital. So more than enough to last her for the rest of her life. There just wasn't any questions about it whatsoever. And she had life expectancy of about 3 to 5 years. She had a really strong lifetime history of gifting. She'd always benefited her son a significant amount, and she'd always sort of been really generous with money and property. And when she had capacity to do so, she'd sought tax advice about income tax and capital gains tax, but not about inheritance tax. And that's quite an important thing here. And her son, who was her attorney, made an application to the Court of Protection, and he applied for a gift of £6 million to himself, about £50,000 to various charities, including Alzheimer's Society, and a gift of £422,800 to be transferred to a discretionary settlement trust, basically for her grandson, his son. And if the person that lacked capacity had survived for 7 years from the date of the gift, the savings to her estate would be about £3.2 million, so really significant savings. And they made an application to the Court of Protection for this to be approved, basically. And the Court of Protection said, thanks so much for the application. I'm really happy you've made it, really grateful for this opportunity to have a chat with you about it. What we're not clear about is why these gifts benefit the person that lacks capacity. We can see they benefit the son. We can see they benefit the grandson. We can see it benefits the charities. But actually, at the point that this tax is going to be paid, she's going to be dead. All of her care fees can be comfortably taken care of as it is. How does this benefit P? So there was a big argument in the court, and they looked at the concept of best interests in depth. And what they said in the court was best interests is not synonymous with self-interests. Okay. So best interests can incorporate an element of benefiting others, provided those others are people that you would want to benefit and have benefited in your life. That sort of benefit reflects back on you, because actually it's something that would make you happy as a person that you're able to do. There's an accepted sort of thing, essentially. And the court concluded that there is absolutely no presumption whatsoever in favour of tax planning. Okay, so it doesn't matter who you are. There's no presumption. Your court aren't just going to say, oh yeah, you're a person, you'd want to save inheritance tax. No, what they're going to look at is your history. And they said it was important that she'd taken tax planning advice in her life. And actually the tax advisors and the financial advisors' notes were all exhibited as part of this case. And they said that it's actually probably because she wasn't old enough to take inheritance tax planning advice that she didn't take it, because she was in her 50s when she started to lose her capacity. And they said that that affordability is absolutely crucial, as you were saying. But just because something's affordable doesn't mean that the gift is the right thing to do. So they looked at her and they said, yeah, she's got a history of taking tax advice. She's got a history of gifting. She's got a history of wanting to benefit these charities, history of wanting to benefit her son and her grandson. Gifts are more than affordable to her. Her son was her appointed attorney, therefore she put trust in him and his views were important. And they said, yeah, okay, in this situation, we'll approve those gifts. So they looked at the entire remit of her history and sort of really weighed it up. And it's quite important as well in this case that, do you remember, when we previously spoke on our podcast before, I spoke about the official solicitor. Now they're the government body that sort of are responsible for representing people that lack mental capacity. When you're making an application to the Court of Protection for approval of gifts of this sort of size or anything that's over and above that sort of small de minimis sort of allowance, the official solicitor would always be appointed for the person that lacks capacity, because normally there'll be a conflict of interest from the person that's applying to the person that is going to be the person that's incapable. There's normally a conflict of interest, and the official solicitor manages that by representing the person that lacks capacity.
Yes, yeah. And I'm just thinking that this also crosses over to my world. There are a number of investment kind of inheritance tax efficient investments that utilize something called business relief. Yeah. And they're promoted quite heavily. And, you know, within a couple of years, if you hold these investments, they can fall outside your estate. And I must admit, I'm a cautious man with my clients' money, and I look at those and I think, you know, especially if someone hasn't invested in something like that in the past, is to go, would they invest in? Why would we go to this level of, you know, this level of individual? I mean, investments which are, in my opinion, have more risk to it than a global equity fund of, you know, 17,000 different companies across the world. You know, they're in a tight regime of where they're invested and what they can be invested in, and to benefit from the business relief kind of tax wrapper, they have to be. And therefore, to me, going, well, they haven't invested in these types of things before. Would they now invest them? You know, are they only being done to, in essence, mitigate inheritance tax for the next generation?
The Court of Protection have looked at this issue in quite a lot of detail as well, which I'm sure you're not surprised about, because it's just as important in terms of inheritance tax planning as gifting is. And there was a particular case back in 2015, REPP, which dealt with this case exactly, where there was an elderly lady who appointed her son-in-law and a professional to be her attorney. So she had joint and several attorneys, basically. So they were both authorised to make all decisions, essentially. She really didn't like her daughter, really didn't like her. And whilst she was the beneficiary of her estate, she expressly said, I want her to pay inheritance tax. I don't want to do any inheritance tax saving. Thank you very much. Now, the attorney, who's her son-in-law, kind of ignored that and did loads of huge gifts to the daughter, including sort of property and money without any authority. So the Court of Protection absolutely wrapped him over the knuckles about that. And I sort of tried to unwind all of those gifts. But he also did exactly what you were just saying, invested a significant proportion of her remaining monies in a business property relief scheme. And the Court of Protection were absolutely livid at him. They said, BB, who's the attorney, and this is a quote, and they say it just much better than I could possibly ever say it. BB did not act in P's best interest in instructing a financial advisor to make investments whose primary purpose was for the saving of inheritance tax. I consider that BB, the attorney, has a conflict of interest in carrying out a review of the inheritance tax saving octopus investments and deciding whether or not they are in P's best interests. The court said that where you're making a significant increase in the investment sort of risk for a client or for P that lacks capacity, where there is any element of conflict of interest, or where there's a significant sort of gearing of risk into increasing risk rather than sort of decreasing risk, then specific authority from the Court of Protection must be needed. So, whilst there is no element of gifting, actually, the impact on the estate of the person that's capacity could be quite significant. There's a risk that's being taken that doesn't need to be taken, and that doesn't benefit them in the traditional sense. So you've got to go to the Court of Protection to see why it's in their best interest that this saving should be made at this stage. It's not to say it can't be done. It can be done. And there are cases where it's the right thing to do, but the Court of Protection will want to sort of sign off on that.
Yeah, it reminds me of a case I was referred a client by a local law firm, and they said, we've got this 92-year-old lady with a significant portfolio with HSBC. Would you review it for her and give us some advice? And I said, well, before we do that, let's just ask ourselves the questions. What does a 92-year-old need a significant portfolio in the equity markets at the age of 92 for?
Yep.
What is the purpose? Because for most of us, the reason we invest is because we're trying to provide for our future. Yeah. And the greatest friend in investing is time. The longer the longer we have, the more opportunity, or the less the less risk that we suffer. And therefore, at 92, you kind of go, well, what is your life expectancy at 92? It actually will be probably 2.5 years, but if you're in reasonable health, but then you're going, well, that's a pretty short term, actually,
very short time frame
in the investment world.
Yeah.
So if you are only investing then for the next generation, possibly actually, and therefore I think this lady did have capacity. So maybe the actual advice should really be is once we've secured the assets that you need for your lifetime, including care, including whatever, actually maybe gifting just normal gifts to the family. Maybe, and it might
be, and that's why it's so important that people take advice from someone like yourself who's SOLA accredited, the Society of Later Life Advisors accredited, because it means that you really understand the wider issues about elderly care, elderly planning, and sort of elderly investments. And that's why I'm a member of Solicitors for the Elderly, because actually I'm proud to hold the accreditation of someone that really understands elder law and the issues about client care and the issues about sort of what it means to be an older person and what their objectives might or might not be. Rather than my client's always the person that lacks capacity rather than their attorney. I'll always be acting in the best interest of the person that lacks capacity. And sure. that was always the bottom line for me.
So, Holly, what can people do? Let's say they've got capacity. What can they do? Gifting.
Well, when you've got capacity, you can do whatever you want in terms of gifting. There's no rules. But if you want to sort of set things up, you want to tee it up, I guess, for a time that you might lack capacity, it would be a really good idea to have very candid conversations with your financial advisor about your preferences, your wishes and feelings, and also to write those down as preferences and wishes and feelings in a power of attorney and make a power of attorney document. One thing you can't do is bind your attorneys. You can't force them. You can't say, you must give £10,000 a year to my daughter, Fiona. You can't do that. But you can say, if I've got spare capital, spare income, I would like this to be considered as something that's in my best interests. It doesn't mean that the Court of Protection application won't need to be made. The Court of Protection application will always need to be made if you're gifting anything over and above those sort of small amounts we talked about at the beginning. But if you've made it very, very clear in writing and to multiple people that this is what you prefer, that would be very persuasive to the court at a later stage where a decision needs to be made about your assets.
And, it's quite an interesting one, isn't it? Because I think people think, they've heard the rules of, well, we can give £3,000 a year away and we can do that each from husband and wife. And then if we missed it last year, we can carry that forward a year and we can make small gifts and we can, but they think the reality is there isn't a limit. There isn't a limit at all. It's just that those gifts.
Well, when you've got capacity, there is no limit. Yeah. Absolutely.
And it's only if you die within the 7 years, that those are brought back into the calculation of what your estate is. It's just that you're not actually. But people do. They see. Oh, we're only allowed to give you £3,000. It's like, well, actually, no, you're not.
And if you've got lots of income spare, then that's even better.
And of course, the regular gifts from income and proving. And I would have thought. How would the regular gifts from income that presumably would be another application if it was a significant
anything over and above 250.
But again, if there'd been a history of regular gifts from income, and it was easily shown that it was affordable, would still. It
depends on the purpose. Say that there's been a case in the last year or two that looked at the difference between sort of gifting and not maintenance, but benefiting. And so I'm not going to go into it because it's actually really nuanced, but there is a situation where it might not count as a gift. It might be a sort of a benefit. And in that situation, you can make more sort of transfers than just the sort of 250 that we talked about. But you really, really need to take very tailored advice about it because the case is very complicated and it's not something that I'm able to go into in any detail at this point. So the best advice I can give to anybody on a broad brush basis is just to make your wishes and feelings as clearly known as possible, maybe with a little side letter, a letter to your attorney saying this is what I would like, but I'm not binding you. This is my preferences. And then that attorney can then take specific advice about whether or not those gifts, those dispositions of money are gifts or whether or not they're benefits, and sort of whether or not an application to the Court of Protection is needed.
Yeah. So I think it sounds like we want our listeners to review their documentation here, to look at it and go, okay, actually, if someone was applying to the Court of Protection, have we got all the documentary evidence to allow them to do that that my wishes can be heard? Yeah,
it's probably worth speaking to a lawyer about it as well, so that you word things in the right way. I always say to people, it's worth spending £500, £1,000 now to save, a £20,000 conflict in the Court of Protection at a later stage. It's always worth sort of a stitch in time saves nine. It's just worth sort of setting things up now if you can.
And of course, it's a bit like many things in life, aren't they? It's very easy to get married, and it's difficult to get divorced.
Oh, I know.
It's very difficult. It's very easy to start a business with a partner or another co-director, but it can be difficult to get out of that arrangement.
Yeah, absolutely.
Therefore, in coming back to being an attorney, to be appointed as an attorney is a lovely thing that someone trusts you implicitly to have that done, of course. But actually, it can be significant work.
It's a lot of work.
And therefore, if you are asking someone to be an attorney, give them all the tools that you can to help them have an easy job.
Absolutely, and that's why. That's why it's okay and it's a completely acceptable expense to use the person that lacks capacity's money to take legal advice in your role. And it's sometimes it's just the right thing to do. It's positively encouraged where things are complicated and you need to take some advice. Take that advice. That's what their money's there for. But there are other times you don't need to. You can just do it yourself. It's fine. But sometimes you really just need to sort of take some proper structured advice and work out the best way forward.
Yes. Yeah. I mean, I'm an executor of a significant estate, not a client, a friend who's in their 80s now, and and it's only because I know the family well, etc. and I have said, I said, you know what? I mean, I know your wishes, but this is going to a law firm. There's
actually, I wouldn't.
There's no way I'm going to do this myself.
I wouldn't service my own car. I just don't know how. I'm really happy to pay a mechanic that knows what they're doing to do that. It's the same thing, really.
Yes, and there is an element also that, especially if there's personal, personal. I know the family well. It's quite nice, the idea that I've got a professional who will be doing it and who is non-judgmental about the personal relationships. We'll just read the documents and know the intent of those documents and go, right, this is how I'm going to execute them.
Absolutely.
Rather than someone going, well, you should have known better, type of thing. Well,
no, absolutely. Absolutely. I think you're doing the right thing.
Of course. What haven't I covered about gifting, Holly? What have I missed?
I think you've just about covered it, to be honest. The only thing that I would say that we haven't covered is where the money is derived from a personal injury award or clinical negligence award. Right. Gifting just isn't really permitted by the Court of Protection. It's just not going to get anywhere with those sorts of applications. It's only where it's private wealth that the money will be able to be gifted in the right circumstances. It's probably worth just covering that, because obviously everyone's got different sources of wealth. So.
And Holly, what's on something I've just thought of off the back of that statement about, so a personal injury award, maybe possibly held in a trust, and obviously for the maintenance and the upkeep of the individual who has been awarded the money, and it may be held within a trust to protect it from certain things. Would that, I suppose, okay, if I'm just thinking this out loud now, I suppose that if the person who had received the award had placed the money in trust, of course, there would be further beneficiaries of that trust thereafter. So wouldn't need to make a will around that.
Yeah, it would depend on the type of trust, because some trusts actually go to a person's estate when they die. Right. So there's no strict rule about that, actually. But yeah, you'd have to look at the terms of the trust.
And coming back to our previous conversation regarding statutory trusts, would that be a scenario where that the statutory, you could apply for a statutory trust, which
statutory will
for that statutory will? Sorry.
Yeah. So yeah, I mean, so it depends on as I said, where you've got a trust situation. There's no set rule about whether or not the money will be yours when you die, whether it will go with your estate or whether it will then go to other beneficiaries of the trust. But if it goes to you and it's your funds when you die, then obviously a statutory will can dispose of those funds just like it could dispose of any of your other assets.
Yeah, brilliant. Well, that's, again, fascinating. Thank you so much. Where, Holly, can people find out more about you and get in contact and get in touch if they need your help?
Well, so I'm the head of the mental capacity group at Mitchell Moores LLP, so I'm quite easy to find. I've got a really unusual name, so just Google me and you can just find me. But yeah, I'm sort of around and about, and I'm on the Wills and Equity Committee, so I'm sort of part of the group of professionals that are sort of keen on sort of making the law in this area and sort of talking to the people that make that law. So I'm sort of always around and about. So if you ever want to get in touch with me, just give me a call, drop me a line. I'm really readily available. So just give me a Google. I'm on Twitter at legal_capacity, and I'm on LinkedIn as well. So yeah, always happy to chat with anybody if they want.
Fantastic.
To.
Well, you've explained some pretty complicated topics in a very easy manner that even I can understand. So I really appreciate that. And so hopefully our listeners will be straight, will be all over it. So once again, thank you so much for your time, Holly, and I look forward to talking.
Really grateful. Soon. Thank you. Thanks, Justin.
Thanks once again to Holly for taking time out of her incredibly busy schedule to join me today. To find out more about gifting under a power of attorney for inheritance tax planning, check out the show notes on our website at theretirementcafe.co.uk, where you'll also find some useful links, including a link to Holly's previous episode on statutory wills and dying intestate. As ever, if you've enjoyed this episode, please do leave us a review on Apple Podcasts. It really does help other people like you find us. This week, I would love to thank World Traveller 6 for leaving a 5-star review with the title Very Valuable, and said, as I start to think about retirement, I have found this podcast really helpful. It isn't just for wealthy people, but really for people who want to live well. Thank you, World Traveller 6, for taking the time to write a great review. I really appreciate it. To watch this conversation, head over to my YouTube channel, Justin King MFP, and be sure to subscribe and hit the bell symbol to receive notifications every time we upload a new video so that you never have to miss an episode. So until next time, I'm Justin King, helping you feel more informed in your retirement.